Hi, everyone. I'm Rick Gaynor, and I'll welcome people more formally in just a moment. We will get started momentarily. Thanks for joining. Hello, everyone, and welcome to this webinar discussion on legitimate land rights, which is being hosted by USAID's E3 Land Office and is being viewed around the globe and live tweeted from the handle @USAID Enviro. I'm Rick Gaynor from the Millennium Challenge Corporation. It's my honor and pleasure to moderate this discussion with our panel of experts, each of whom is going to provide us with understanding and perspective on this issue through his or her distinct lens. Before introducing our panel, I want to invite you, the audience, to participate actively in the discussion by tweeting your questions and comments to the event on Twitter using #LegitLandRights. We know you're out there. We've had a great response. In fact, I'm told this is the largest audience for one of the land office events. Please tweet liberally. And we will also be posing questions to you in the form of polls, and we hope you'll participate in those polls. We'll do our best to answer your questions, whether directly online or posing some of them to our panelists during the course of the discussion. Let me briefly introduce the fantastic panel that we have today. First, Brian Keene, who's an advisor for Indigenous Peoples issues at USAID, spearheading efforts that U.S. development assistance is carried out in a way that recognizes and respects the rights of Indigenous peoples and involves them in the process of designing and implementing programs and projects that might affect them. We also are joined by Kate Matthias of Olovo Sugar Limited, which is the largest sugar producer in Africa and is a major supplier to beverage companies around the world. Olovo operates in 6 countries in Africa, including the world's poorest countries. It's one of the countries that's taken the zero tolerance of land grabs pledge in its supply chain. And Kate has been working for over 15 years helping Olovo develop and implement their land guidelines and land roadmap to ensure engagement with communities and good land governance in their supply chain. We're also joined by John Lindsay, who's lead counsel at the World Bank and has worked extensively on the legal dimensions of the bank's activities related to land rights, land tenure, and management, as well as initial preparation and now redrafting of the bank's social safeguard policies, especially those related to resettlement and indigenous peoples. Finally, we have David Grossman, who's the Director of Global Programs Management at ICMA, the International City and County Management Association. David has 30 years of experience in international development with a focus on municipal development and expertise in finance, credit, and urban infrastructure. Before giving the floor to our panelists, I want to provide a little bit of background and context on this issue of legitimate land tenure rights from my personal experience. As I mentioned, I'm from the Millennium Challenge Corporation, MCC. For those of you who may not know MCC, we're an independent US government agency created in 2004. Our mission is to transform lives and create opportunities by partnering with the best governed poor countries to reduce poverty through economic growth. Since our inception, we, along with our partner countries, have prioritized investments in improving land governance and strengthening property rights in ways that will stimulate economic growth. So this issue of legitimate land tenure rights is near and dear to our hearts as we implement our programs with our partner countries around the world. To set the context for the discussion, I want to remind folks that the term legitimate tenure rights was really put on the map because of its use in the voluntary guidelines on the responsible governance of tenure to land, fisheries, and forests in the context of national food security. I figured I would say the whole title once, but since we only have an hour, I will hereafter refer to the guidelines as either the VGs or the voluntary guidelines. The VGs were adopted 4 years ago by the UN Committee on World Food Security, and they were the product of approximately 2 years of extensive consultations and negotiations that included governments, the private sector, and civil society representatives. I participated in that process as the lead of the US government negotiating team. And I can say that I've never been involved in a process that was so participatory and inclusive. And I think it's because of that that the VGs reflect a globally agreed framework and principles and standards for the responsible governance of tenure. The phrase legitimate land tenure rights is used widely in the voluntary guidelines. I think it appears something like 45 times. But notably, it's never defined. And as a participant in the negotiations of the VGs, I know that there were a lot of important compromises that were struck during those negotiations. One of the most important, I think, was that we decided to use that term, legitimate tenure rights, and we decided not to define it. And I think the lack of a definition, a formal definition in the document, is maybe one of the things that made it possible for the unanimous endorsement of the voluntary guidelines, because it allowed everyone to bring their own interpretation to the term. On the one hand, that allowed a narrow interpretation whereby a right could be denied legitimacy in accordance with national legal systems and their institutions. And that was important to some of the participants in the negotiations. On the other hand, it allowed, and maybe more importantly for today's conversation and discussion, it created space for an expansive interpretation of the term, which was embraced in many ways by the voluntary guidelines. And that's a concept that legitimacy of land tenure rights can derive from a variety of tenure systems, whether they're statutory or customary. A tenure right can be legitimate even if it's not statutorily recognized. Similarly, a legitimate right can extend beyond mainstream notions of private ownership and include rights of non-owners who have traditional rights, such as nomadic pastoralists who have seasonal rights to grazing areas. And also you see in the VGs the notion that legitimate rights are not necessarily, they don't necessarily need to be formalized or recorded. They can have social legitimacy, and when they're recognized by local communities and others, they have legitimacy through that, even if they're not written or recorded. So in the 4 years since the endorsement of the voluntary guidelines, the global community, including the state's civil society actors and private sector who were engaged in the preparation and negotiation of the voluntary guidelines, have now turned to implementing those guidelines. And at the heart of implementation of the guidelines is the topic for today's discussion, and that's an effort to understand what is meant by legitimate tenure rights and why that term matters. And one of the nice things about being a moderator is I don't have to try and answer that question myself. I have the panelists to help me with that. And so at this point, I'm going to turn to the panelists, and I'm going to invite each of them to just make a brief comment on the issue of legitimate tenure rights from their organization's perspective. And I'm hoping that the panelists will keep these comments to maybe 3 or 4 minutes, because we'll have plenty of time to delve more deeply into their responses. So first, Brian, if you could talk a little bit about the issue from your perspective.
Sure. Thank you, Richard, for hosting this important conversation. So I'll be looking at it from the perspective of indigenous peoples. First, why it's important that indigenous peoples' land rights, customary land rights, are considered legitimate. It's important not just for their continued survival as distinct peoples, but it's also important for the rest of us. Studies increasingly demonstrate that the most effective way to protect forests, to protect biodiversity, is to recognize the land and resource rights of indigenous peoples. Their territories are home to over 80% of the world's biodiversity. They're stewards to over 90% of the world's genetic diversity of food crops. And this is all important as we try to respond to the challenges presented by global climate change. So from USAID's perspective, what we're doing, first, USAID and the US Department of State last year in the Quadrennial Diplomacy and Development Review, we recognize that indigenous peoples have a key role to play in biodiversity conservation, sustainable development, and finding effective responses to the challenges presented by global climate change. In the QDDRs, as known, Quadrennial Diplomacy and Development Review, we specifically say that we will work with indigenous peoples as partners in the development process. We will support the legalization and demarcation of their territories and strengthening of their traditional resource management strategies and livelihoods. And so with the Land Tenure Office, what USAID is doing is working to strengthen land tenure rights around the world and make sure that the systems that govern land tenure rights are effective and responsive to the needs of the people that actually live on the land. This is important in meeting all of the objectives and goals that USAID has set out, whether it's economic growth, poverty reduction, conflict resolution, food security, land tenure, and resource rights is key to that.
Okay, I'll stop you there. I know you can talk more about USAID's involvement in the issue, and we'll give you plenty of opportunity to do that. I want to turn now to David to tell us a little bit about the issue from the perspective of ICMA. David.
Thank you, Rick. It's hard to just tell a little bit, but we'll start with a little bit and hopefully get to more. So for the viewers, ICMA is a professional association of more than 10,000 local government professionals, including several hundred international members. ICMA was established in 1914 to promote professionalism, good governance, anti-corruption, transparency in local government. So clearly, I'm going to address this from the perspective of urban citizens who do not have tenure, who may be squatters, or who maybe have legitimate claims to their properties, but simply because of the lack of administrative processes in the municipality do not have a piece of paper that's a title, but have to use proxies. So this is a critical issue with respect to urbanization. Currently, 1 in 5 urban residents are slum dwellers, do not have title, and beyond the slums, as I said, because of the lack of administrative processes and capacity, the numbers of urban dwellers without titles exceeds that. And those numbers are growing. The slum populations are projected to double.
David, now I'm going to interrupt you there and turn to John for a little bit of perspective from the World Bank.
Hi, everybody, and thanks, Rick. Well, at the World Bank, very, very briefly, we're engaged in the fight to eliminate poverty, as many of the people on this call are. And in many parts of the world, we know that people's wealth and livelihoods are or their aspirations to wealth and livelihood are tied up in land. So that's the simple answer. Yet we know that we can find ourselves at just championing those with formal rights recognized by written law. We leave out of the equation many ways in which people hold and use and transact land, ways that are in many ways long recognized as legitimate within local societies and notwithstanding what national law says. So that I just want to get a chance to talk about this in more detail later. I want to put on the table 3 ways in which I think the legitimate rights help us in our work and help I think push this dialogue forward. First of all, it provides us with a vocabulary that helps us move beyond time-bound or hide-bound conventional and judgment-loaded dichotomies between legal and extra-legal, between formal and informal. It critically breaks up the assumption that legitimate is necessarily defined by law, and that any recognition of non-legal tenure is a concession on the part of the gatekeepers of legal legitimacy. Secondly, and a variation on the previous point, I think it also moves the discussion beyond customary rights in the context of indigenous peoples, where there's a well-established international law and international constituency, into a broader arena where in multiple social contexts, legitimate land rights may exist, but without clearly falling into a well-established internationally recognized category. This has been happening for a long time, but I think the legitimate land rights discourse helps that. Finally, it provokes those who are seeking to give more formal protection and recognition to rights, such as the governments that we support at the World Bank, to focus on what rights are what rights actually are in practice, rather than trying to cram people's relationship with land into predefined legal categories. And so in this sense, it exhorts us to take into consideration the many ways in which people use and depend on land that our standard titling laws and titling approaches do not pick up in value. So let me stop there. I'll try to elaborate on some of that as we go forward.
Okay, great. Thank you, John. And Kate, now a little bit about this issue from the perspective of Ilovo Sugar.
Thank you. Ilovo Sugar is one of the largest sugar producers or the largest sugar producer in Southern Africa, and we operate on about 64,000 hectares of our own land, but with about 113,000 hectares of outgrower land into our supply chain. So land's a very important part of our business. Being an agribusiness, it's also it's the foundation of the business, and we within our supply chain we're operating with people with formal rights, informal rights, cultural land, traditional rights, and we're trying to get an understanding at the moment through our sort of implementing a comprehensive land program of what our status is on land and how we're going to address some of the issues around land. As you said, we're operating in some of the poorest countries in the world where pressure on land is increasing, and we are finding that for operational reasons of cane supply and being able to keep the business running, we need to better understand and assess our situation and put together some roadmaps on how we're going to address land in the various countries we're in. We have put out a policy statement. We've put out some guidelines on how we're going to implement our land program, and we've got a roadmap in place. We've got a very comprehensive roundtable to bring in expertise, because this is not our area of expertise, and we're very much at the early stages of implementing this land program.
Okay, great. Thank you for that perspective. Thanks to all the panelists for a little bit about where they're coming from on this issue. David, I wanted to come back to you. I was happy to see on the invitation for this webinar that it featured a photograph of an urban area, because often we think about this issue in more of a rural context. But I wanted to start with probing a little bit more with you on what legitimate land rights means for squatters' rights, and when, if ever, squatters' rights can or should be considered legitimate.
Thank you, Rick. I'd like to point out that the Habitat 3 New Urban Agenda, which has just been finalized actually in the last few days for the upcoming Habitat 3 conference in Quito, contains the concept of rights to the city, which I think might be a sort of a parallel or compatible global accepted statement to the voluntary guidelines. And while it also needs a lot of definition, my understanding is rights to the city means not only land tenure rights, but rights to services, an array of services that all citizens in the city should benefit from. So if managed well, land tenure in cities should produce a range of benefits to all citizens. It should leverage economic investment and development. It should yield significant and growing revenues to local government, and this is in the form of the real property tax. It would create more stable and inclusive social conditions through the provision of social services. And by providing easily accessible and spatially enabled up-to-date land information as a convenient and accurate base for many planning functions, it would help rationalize a lot of different systems, especially real estate markets. So land tenure is a trigger for many different aspects of rationalizing and providing a good quality of life in cities. Thanks.
John, I wanted to come back to you. You've already alluded to the diversity of land rights and the potentially broad interpretation of what legitimate tenure rights might mean. But I wanted to probe a little bit more with you on what rights can mean to different members of communities. Communities are not necessarily homogeneous. Even households have different members. And so can you talk a little bit more about what legitimate tenure rights mean for different members of a community, and that often includes women, herders, others who are considered vulnerable.
Well, I think thanks, Rick. I think you've touched on one of the more difficult aspects of the whole conversation. Also, an area where there's I think a great deal of opportunity. I mean, as you mentioned, it's a term that's not defined, which is both a blessing and a curse. It gives room for basically an adopting approach that could be summarized by, we're not exactly sure what legitimate rights are, but we are pretty comfortable that we know it when we see it. The guidelines mention a range of tenure rights, such as public, private, collective, and so forth, but it doesn't say that all of those are legitimate. Some of them will be legitimate, some of them won't. And in terms of the challenges you find within particular communities, the analysis of what rights to count as legitimate is complicated by local political economy. Prevailing perceptions of legitimate tenure may differ extensively within a community, between communities and the government. Society may be defined, the society itself from which you're deriving legitimacy may be defined in multiple overlapping ways, from a community practicing local rules regarding access to grazing land and water rights and so forth, to societies writ larger across a local or national landscape. But I think one thing that is, I think, helpful with the whole concept of legitimate rights, again, looking at it from the perspective of our own practice here, is that it does help us move beyond sort of narrow description of rights and force us to look at or exhort us to anyway, look at it at a wider category within a particular community. As I said before, it helps us try to change the discussion from what does the law prescribe as a right to looking at what are the ways that people actually use land, and how do our legal forms and our legal processes need to catch up with that vision as opposed to the other way around. So this means implicitly that there has to be a focus on looking at secondary rights, common property rights, multiple tenure systems, and the like, in the context of the more traditional approaches to formalizing tenure that we've adopted in the past.
Thanks, John. Kate, I wanted to follow up on that with you a little bit. We know that Alovo Sugar has been on the forefront of the private sector's efforts to help respect and identify legitimate tenure rights. But probing further on this issue of those who might be vulnerable, can you tell us a little bit about Alovo Sugar's experience with having to go a little bit deeper in identifying the rights of members of families, members of communities, how you treat that?
Thanks. Yeah, I mean, I don't disagree with what John was saying at all. The traditionally we would have gone legitimate would have been the legal right and who holds the lease, and we're increasingly understanding that we have to look deeper than that. As I say, we're very much at the early stages of doing this, but for example, in Mozambique, where we're doing a new smallholder development program, we have done a significant proportion of civic education and social mobilization to really find out who we're dealing with and who we should be engaging with, measuring each Canva plot that we're working with, and getting people to understand really what it will mean to their rights over the land, their use of the land, how their boundaries will change, and getting to understand who are the rightful owners, making sure that the whole how vulnerable groups and the women are involved in the conversation, in the training, so that we know that the people that we're engaging with are the right people, and that we're not going to later on find people that didn't really understand why their land had to be blocked, why they can no longer grow vegetables in that particular bit, that's sugarcane, and they want vegetables. So it's a long process, and it's an easier process to implement on new investments and new projects than it is to go back and assess some of our existing programs and projects. And I think we'll probably talk about that a bit later on. But I think it's recognised across the private sector that just the legal documentation is no longer enough when looking at land and looking, in either new investments or new smallholder programs as such. You have to go a lot deeper now.
Okay,
and it's an operational risk as well.
Yes, and we're going to talk more about the operationalization later. And in fact, I'm going to touch on that a little bit with Brian, in terms of, it's already, the panel has already mentioned that land rights don't necessarily need to be formalized or recorded to be legitimate. But what do we do when there is no individual title or titling system or piece of paper? How do we operate in those kinds of contexts and try and understand who are the holders of legitimate tenure?
Great question. Well, with respect to indigenous peoples, I think international law is pretty clear that indigenous peoples have the rights to collectively own their lands and resources. That has been confirmed or affirmed in decisions by the Inter-American Court on Human Rights, by the African Court on Human and People's Rights, by various UN human rights bodies. And this is a question that we all need to really examine and try to resolve. Corporations, the private sector, development agencies, and governments. You might be familiar with the London Group study that came out a couple of years ago, which found that over 93% of the lands concessioned off for logging, mining, oil development, agriculture are lands that are occupied. And often those lands are concessioned off without even the knowledge. The people who live there don't even know that this is happening. And this is creating all kinds of problems. So there is a...
What are some of the best practices and things that can be done in those kinds of...
Okay, so I think with indigenous peoples, we need to develop a process for free, prior, and informed consent. Whether we recognize that as a right or not, we need to use it as a mechanism to ensure that all the other rights are respected. And it has to be done through indigenous peoples' traditional representative bodies. It has to be done in a way that gives them the time and the space needed to make decisions. And I think that, as several people mentioned, legal does not always mean legitimate. So we've got cases, say, in the Chaco in Paraguay, where for decades, land that indigenous peoples are living on has been being sold off. In my view, that is not legitimate land rights. And then we have the question of countries where the governments own all of the land, and they make decisions without the consent of the people living on the land to move people, and those are all issues that we need to address. And I think that development agencies, international financial institutions, and the private sector have to be very careful about supporting projects where within the local legal system, it might be viewed as okay to move people off the land for a project, but according to international best standards and the reality on the ground, it's not being done in the right way.
Thanks, Brian. I want to turn now a little bit to a consideration of sort of the opportunities that are posed by the lack of a formal definition of legitimate land tenure rights. And you know, particularly, I'm thinking about this in the development or business context. And David, I wanted to get your thoughts on whether individual, you know, a lot of governments, a lot of development professionals assume that individual titles are a stronger foundation for economic growth than either customary titles or informal rights. And I wanted your perspective on whether individual titles are necessarily a stronger foundation for economic growth from a development perspective.
Well, I have to say, I feel that yes, the more formal and secure an individual title could be, the more effective it could be in leveraging loans and leveraging that capital asset. Now, the reality is that that's not even an aspirational goal in most secondary cities to get to that level. Therefore, there need to be proxies that can serve the same purpose. We're working in several secondary cities in the Philippines where a property tax declaration from an assessor's office is the proxy for the title, and that works. So it's a very expensive proposition to survey the boundaries of all the property units in a city, and particularly when you have expansion areas because of the influx, the immigration into your cities. Secondary cities are going to grow very rapidly, and there have to be low-cost ways to address the surveying and the titling process. And there are.
How do you get citizens and governments to accept those less formalized proofs of rights that you've talked about?
Well, I think it's a process like all matters, local government, of citizen engagement and inclusivity. The process of land use mapping has to be very participatory, and zoning decisions and infrastructure decisions and all aspects of land use mapping, including a territorial approach, not just the city, but the peri-urban and rural areas that are part of that one economy and the value chains that connect rural and urban areas. So through a participatory process and working with the financial sector in terms of lending and mortgage lending, in particular with respect to real estate markets, all this has to be accommodated. And I think the goal is to formalize the informal, but it's going to be a long-term process, and as we're noting, proxies have to serve the purpose in the interim.
Kate, on this theme of opportunity, I imagine that a lot of people think of the private sector's perspective as being one of challenges in relation to lack of clarity around tenure rights. But can you maybe talk about how from a private sector perspective, the honoring of legitimate tenure rights might increase the return on investment, or is basically a business opportunity for you?
Yeah, I mean, formalization of land rights would help very much along the supply chain. It helps us in understanding our supply chain better and being able to be more comfortable that we have an ethical and sustainable supply chain. And it also helps, for example, if we're doing smallholder development, if we've got formal land rights, it helps us with financing agreements. It helps us with a whole range of making sure that we are engaging with the right people. The complexities around land, when you're sort of dealing with the different land systems, the traditional systems and the government systems they're very difficult to deal with. Even if we're not talking about sort of expansion areas and just talking about, for example, our own estates with where we have the land, the legal land rights. There are areas of it where it's conflicting with the community's understanding of how and the issues around how those legal land rights were acquired, not necessarily by us because we bought the businesses, but by the previous business. So you're talking about how those land rights were acquired some 60 years ago in some places, and it creates a lot of operational difficulties when you have conflicts with communities around your estates, or you have conflicts between your smallholders, and these are conflicts on land at a community level, like intra-community, even intra-family, and it can stop operations. It can be costly. It's very a sugar factory needs a constant supply of cane, and we need to know where that cane is coming from. You can't stop and start the mill. So if you have operational difficulties and conflicts over land, and either farmers can't supply certain parts of from certain areas, or crops, they stop maintaining areas because of land conflict, it has a real costly impact on the business. So formalizing it and understanding it and making sure that they are legitimate land rights is crucial to the business.
John, I want to maybe pick up a little bit on the challenging aspect of this that Kate was just alluding to. Can you talk about some of the practical challenges that either countries or you at the bank have faced when you're trying to honor legitimate tenure rights?
Sure, there's a couple different types of challenges. One, I suppose, is the fact that the World Bank, as with many international financial organizations, deals primarily with governments, and governments tend to believe that they know what is legitimate and what isn't. So if you use the discourse of legitimate land rights, they tend to tell you that they know very well what's legitimate. Thank you very much. And so then it becomes an important and difficult task to try to continue that dialogue and get some acknowledgement of the fact that there are alternative ways of looking at legitimacy. Then we have there's the challenge that arises in particular geographical contexts. I mean, thinking of some work that we've done in Ghana, for instance, but this could be replicated almost anywhere in the world, where in anticipation of helping to facilitate community interaction with agribusiness investors, we may find in particular areas land registered in the name of the state because of a taking that happened many years ago. It's legitimately there in the name of the state. At the same time, you find people around who are aggrieved because that taking didn't happen legitimately. Land was taken and the incorrect amount of compensation was given, or people's rights were ignored. There are now new communities living on the land and managing it according to their own customary rules that they consider legitimate. And then increasingly you're finding chiefs of the community living on the land beginning to use instruments of national law as a way of formalizing their personal rights to the land sometimes at the expense of their role as trustee of the community. So these are the types of complications you run into when you try to operationalize or try to drill down in a particular context as to what is or is not legitimate. I think one thing we need to put on the table and talk about as a group a bit more is that despite the absence of a definition of legitimate rights in the voluntary guidelines, at the end of the day, what the voluntary guidelines puts in place is an important it puts in place is important concepts around process and how the whole voluntary legitimate land rights may not be defined, but the voluntary guidelines put in place or call on governments and other stakeholders to put in place a transparent, open, considered process for determining what is legitimate, what isn't. And I think that's the crux of the matter. Is there a solid procedural framework within which that discussion can take place?
Yeah, and Brian alluded to in terms of process, the concept of free, prior, and informed consent, and engaging with those who may be affected. David, I wanted to probe also a little bit further with you on this context of squatters and the growing pressures on land, and particularly in cities. And when people move into areas where they may not have any right, and there may be people who claim pre-existing rights, what do we do in terms of the process?
Well, the easy answer, of course, is for cities, and particularly secondary cities, to be ahead of the curve and to have a planning process in place that for the absorption of these new citizens. But I think there are different approaches to squatter settlements. I mean, the first decision is whether the settlement is in a safe and healthy location. If it's on a riverbank, on a steep slope, I mean, that's the first determination. Should people be living on that piece of land or not? If so, then they should be. Every attempt should be made to incorporate them into the overall systems that the city is using, and to take a pro-poor approach to the overall systems of the city in terms of creating a unified land information system, for example, including these squatter settlements, and try to regularize them as best as possible. If the land is not suitable, then the residents should be incorporated into adjacent communities or through a consensual negotiation, move to places where they still have access to transportation to work and urban services. And if land were evaluated properly for not only for tax purposes, but for this type of compulsory land acquisition and compensation, these people should be compensated and supported as well. So, in a situation where you have absence of land record management, informal land transactions that are not being recorded, the quality of the land survey records is poor, and you don't have real market values matching up with tax declaration of values. There's a lot of reliance on looking at the conditions at hand, dealing with the particular population at hand to seek either immediate remedy in terms of relocation or a longer term solution to try to formalize the informal, as I said earlier.
Brian, coming back to you on the notion of free, prior, and informed consent. It's a term that's obviously used widely. Sometimes not all governments agree completely to what it means. But in terms of operationalizing, you know, some people fear that it might give almost a veto power when you talk about consent, as opposed to consultation. So can you talk a little more about the challenges around operationalizing pre-planning?
Yes, I think it all comes down to how do we ensure that there's really good faith dialogue happening with communities around development and around specific development projects. We need to sort of get beyond the check the box way of doing consultations. There are many examples of consultations that really aren't done that well. And it's up to the funders, the private sector, the international financial institutions, and bilaterals like USAID to do our own due diligence and to really insist that this good faith dialogue is actually happening. So operationalizing something like free, prior, and informed consent is not simple, and there's no one size fits all that's going to work. But there are a number of principles that are expressed in the UN Declaration on the Rights of Indigenous Peoples and the outcome document of the World Conference on Indigenous Peoples, the special session of the UN General Assembly that took place in 2014, where governments commit to engaging Indigenous peoples through their own representative institutions in order to obtain their free, prior, and informed consent. So sometimes that may mean a veto, but that's not the sort of main reason for doing this. It's to have better outcomes. As you see in the sugar industry and other industries, when these questions aren't dealt with, it costs a lot of money. It creates a lot of problems for a lot of people, not just the companies involved, but for the people involved. And so that's the way development is moving. And I'll also say that we can't look at collective land rights and development of Indigenous peoples or Indigenous peoples development solely through the lens of economic growth. So that's not always sort of the main objective for development. Indigenous peoples have been promoting for decades or more this concept of summa causa, it's called in Quechua, which is good life, and we need to start moving towards a development system that includes these kind of concepts, like and develop indicators that are appropriate for Indigenous people. So economic growth might not mean a better standard of living for Indigenous peoples. You could have people who have everything they need and don't make a penny, but they've got food, they've got clean water, they've got healthy communities. And if you go in there with a big agriculture project or a big infrastructure project, they may get jobs. So on paper, they're making some money, so it looks like they're better off, but in reality, they're impoverished from their point of view. They're much worse off. So that's the trick is, you know, how do we incorporate these views into our development model? And that's something that I think everybody on this panel is working towards.
Thank you. Kate, I wanted to turn back to you and maybe position with what Brian just said is, you know, you represent the private sector perspective, but you talked earlier about some of the challenges around legacy issues, and I wanted to go a little deeper into that issue. I mean, there are often so many historic claims. How do you, from the private sector perspective, make sure that the people who should be consulted are consulted and involved?
Yeah. Maybe just to add on what Brian was saying first, the communication side of it is really challenging as a big company, for any big business, and being able to communicate on a level with the communities to be able to sort of negotiate any program or any expansion is really challenging. You've just got completely different goals and different levels of understanding. You are dealing with traditional routes of communication which do not necessarily always reach the grassroots level. So you know, you're supposed to follow the traditional routes of local government or chiefs or whatever, and whereas you know that the message may not actually get down on the ground, and you may not be getting the feedback from on the ground. So it makes it very challenging in communicating anyway, with communities about any issues, land or anything else. It's also very difficult when you're discussing land, be they legacy or be they new ones, with the communities, because when you are in a position where you are service provider in the area, so you're not on a level playing field, and this is where we really need to sort of engage with civil society to get better representation of the communities and better build the capacity of the communities and civil society, so we can sit and talk about land and about other issues. And this is what we need to do with the legacy issues. We have problems in some of our countries of legacy issues, and you know, they're no secret. They're well known in across the sort of landscape that we're talking about, where we're talking about land that was allocated to sugar some 40-50 years ago, and is now being questioned on the legitimacy of those original land leases. And if I had the answer of how to deal with it, I think, you know, I'd probably be quite rich as well. But I don't have an answer, because, you know, it's every situation is different. And we are trying to, but engagement and talking and communication is really the only way to go to start talking about these issues, for us to understand the community's point of view and the community's needs, and then for them to understand the business point of view and the business needs for land. You know, it's really important, and this is the type of dialogue we're trying to establish and trying to get moving, so we can start to address some legacy issues. I don't know. Maybe I throw it. I'm not a land expert, you know, and we're not land experts. Maybe I throw it back to the experts on how do you deal with legacy, and you know, how far back do you go? It's, you know, it's a real challenge, but it has an effect on the business and on the day-to-day operations of the business, and it's different in different countries. And then we've got different legacy issues, you know, even in our smallholders, where they've got conflicts over land and land rights, because, you know, back in 1960 something, a whole, you know, communities were moved off because areas were going to be developed. They weren't developed. New people moved on, and some of the old people moved on, and some 40 years later somebody wants to develop that area, and you've got a conflict over who's the rightful people to work with and develop. And people that were squatters for 30 years, are they the rightful people, or the people that used to have it back in 1950 something? You know, it's a really challenging situation to have to deal with, and it's one where we are obviously trying to do it, and we have found that this sort of engagement with experts is really, really helpful, because we don't, as an industry, have the answer, and other businesses are dealing with it. It's not just the sugar industry. A lot of big businesses are dealing with it, and it is not going to go away as the pressure on land increases, and we have to work out how we deal with it. I don't think that the answer is always, you know, giving back land, because who do you give it to? How do you identify this? But also it affects the profitability of the business, which then affects the livelihoods of workers and other communities. But what you have to look at, we have to get a better understanding of what it means to each of the parties, and certainly we've really benefited from, you know, getting, say, maybe a sociologist or an anthropologist point of view on some of these issues that can help us give a a real better understanding of what the root of these issues are. So I don't have an answer, but I hope you do.
Yeah, well, I already invoked my prerogative as moderator to not feel obliged to have answers, just to pose questions. But I did want to, and I think you're right. You know, there are not necessarily answers to all these questions, right? It's a question of process, of engagement, of conversation from these different perspectives. We are almost out of time. David, one final question for you. How do we even engage with a squatter community, for example? I mean, Kate's just talked about engagement from a private sector perspective in a rural context, but how do we even engage with a community in an urban context?
I mean, citizen engagement is just a key force of within local government in this country and internationally. It's a component of every program, every consultancy that we're doing globally, whether in the area of local economic development, public safety, climate change adaptation. No matter what the program, citizen engagement is essential, and local governments have to have the ability to reach out and engage all stakeholders in society, not only the marginalized and the poor, in order to achieve a citizen-wide consensus in terms of moving forward. So I think with respect to land tenure, approaches have to be citizen client-driven. They can't be technocrat-driven. Characterized by responsive service standards, which are publicized. People are empowered and demand better service. Open and accessible land ownership information, that's the transparency aspect. Policies, laws, and procedures should be streamlined to meet cost-effective delivery of services. These services need to be affordable and not so complex that people have to hire fixers to get their land title. And with respect to the local government, the services need to be, the performance needs to be benchmarked, and there need to be independent monitoring, watchdog monitoring of this performance. So citizen engagement, outreach, involving all stakeholders, and there, in our public safety programs, we have public safety committees that are made up of civil society. There are civic groups and NGOs working and present in almost all of these communities that are representative of the community. There are religious-based groups. So all of these organizations need to partner and come to the table, and the local government needs to convene all of these stakeholders to get a truly representative voices in the process.
Thanks, David. We have already gone a little bit over time, and we have a ton of questions from the audience, and I want to thank the audience for the lively participation online. We'll be sharing and submitting the question and answers after this event in a follow-up email. But thank you all out there in cyber world for your participation, and thanks to the panelists also. I think it was a lively conversation. I knew at the outset that it would probably be a little bit frustrating to try and cover this issue in an hour from all these different perspectives, and that we would scratch the surface. But I think the encouraging news, and just in wrapping up, is that the adoption of the voluntary guidelines did bring a lot of momentum to the discussion of this issue, just as was intended by the adoption of the guidelines. There's been a lot of convergence on this issue from different perspectives, and that's reflected in the perspectives of the panelists. So you have governments realizing that they need to do a better job of recognizing tenure rights, whether they're formal or informal, recorded or not recorded. You have companies, the private sector, understanding that they need to do the same, and certainly communities have been empowered, I think, to be better at asserting their rights. The donor community is more sensitive to the needs in this regard. So I think, you know, the progress has been great. I wish we had more time to talk about the issue, but once again, I'd like to thank the panelists for the lively conversation, and I'd also like to thank USAID's E3 Land Office for hosting this discussion. I'm sure there will be interesting follow-up opportunities. Thanks again, everybody.
Thank you, Rick.
Bye-bye.
Thank you.
Thank you.